Thank you, and Assalamu alaikum. I've recently taken on the role of Director of Strategy for the Center for Islam and Religious Freedom. I also have almost 7 years of experience as an attorney working on both international and American religious freedom issues at the Becket Fund for Religious Liberty. The Becket Fund is a nonprofit, non-partisan law firm dedicated to defending the religious freedom of people of all faiths. Muslims, Christians, Zoroastrians, Sikhs, Jews, Santerans, Amish, you name it. It exists to vindicate a simple but frequently neglected principle, that because the religious impulse is natural to human beings, religious expression is natural to human culture. It should therefore be allowed the freedom to flourish. In its 2 decades of work, the Becket Fund has handled cases ranging from the non-controversial to the sort of controversial to the very, very controversial. The more we move out of the easy cases into the trickier ones, the more politicized the case becomes, and the less consensus we have among, for example, conservatives and liberals. The Becket Fund, as a nonpartisan firm, doesn't get involved because of any political agenda. Its motivation is the same regardless of the issue at hand, defending the fundamental right of all Americans to live in accordance with their faith to the fullest extent possible in our legal framework. And yet consistency in our mission hasn't prevented others from politicizing our cases. As the culture wars rage, my experience has been that American Muslims, especially young Muslim leaders, tend to align themselves with a liberal position. And they do so with what seems like a total lack of understanding about how their position will impact the Muslim community as a religious community. We sometimes protest that others have racialized Muslims, but when it comes to thorny religious liberty issues, the community's gut response is one that forgets that we are first and foremost a religious community, not an ethnic or racial minority. Untangling the two is important. Even with everything else on our plate, we have to think strategically about how specific religious liberty cases will impact religious freedom jurisprudence, which in turn determines how far the government can go in encroaching on our religious exercise. As a minority religious group, and a deeply misunderstood one at that, we have to make sure that the law continues to provide us with strong protections. So I earlier mentioned that our cases range from the non-controversial to the very controversial. I wanted to go over a few examples in each category and of course focus on the hot cases. I also want to briefly touch on the core legal principles at issue in each case. In the non-controversial category are matters that, for example, deal with land use, religious garb, or prisoners' rights. The Becket Fund has done some great work in each of these areas, including on behalf of Muslims. In the prisoners' rights context, there's a key religious freedom statute called the Religious Land Use and Institutionalized Persons Act, or RLUIPA. RLUIPA embodies a very simple principle. Prison officials should not impose egregious and unnecessary restrictions on religious liberty. Stubborn bureaucrats cannot strip inmates of human dignity by denying them the ability to seek God. Despite RLUIPA's protections, some inmates still face persecution for peaceful displays of religious devotion. We've helped Jewish inmates gain access to kosher meals, and we've even helped members of the Nation of Islam gain access to their religious literature despite unbacked evidence that it would cause religious tension. We also last year represented a Muslim inmate at the US Supreme Court. In the case of Holt v. Hobbs, Abdul Muhammad, an Arkansas inmate, wanted to grow a 1/2-inch beard in accordance with his religious beliefs. But Arkansas denied him this right, even though it allowed other prisoners to grow beards for medical reasons, and even though 44 state and federal prison systems across the country allow prisoners to grow beards and have never dealt with any problems because of it. Arkansas, thus, was a classic example of a prison system placing arbitrary limits on religious freedom, concocting justifications with no evidence to back them up. So Mr. Muhammad filed suit representing himself all the way to the US Supreme Court, at which point the Becket Fund learned about his case and stepped in. And on January 20th, 2015, the Supreme Court ruled unanimously in favor of Mr. Muhammad. Another case won unanimously at the Supreme Court and in which the Becket Fund filed an amicus brief is Equal Employment Opportunity Commission v. Abercrombie & Fitch stores. The case involves Samantha Eloff, a young Muslim woman who wears a headscarf as part of her faith. Eloff sought a job at Abercrombie, a preppy clothing store in Tulsa, Oklahoma, that won't allow employees to wear anything on their heads. She didn't get the job. When the hiring manager saw Eloff's headscarf, she realized that it violated Abercrombie's official look policy, so she had to ask the district manager whether they could make an exception. The hiring manager thought, but she wasn't really sure the headscarf was religious garb. The district manager said they couldn't make an exception. His reasoning was, quote, If we allow this, then someone will paint themselves green and call it a religion, end quote. The legal question at the center of the case was, if a job applicant would need some sort of exception to be made to a company policy because of her religion, is it her obligation to mention that in her interview, even if she doesn't know about the company policy? The court said no and ruled in favor of the religious job seeker. In the land use context, the cases that are easy legally can be quite difficult socially. A classic example of a case where the social trend was against Muslims is the so-called Ground Zero Mosque or Park 51 cases. The more controversial cases that I'll be talking about later is where the social trends are going toward conservative Christians. So getting back to mosque controversies, it's certainly not limited to New York. A more recent case, and one you may have heard of, involved the Islamic Center of Murfreesboro, Tennessee, which was able to go ahead with its expansion plans despite intense local opposition. Having been around for more than a decade, it was time for the Muslim community in Murfreesboro to build various community resource facilities. After the county approved the expansion plans, controversy and protest erupted. Some protests drew hundreds of people, and the protesters vandalized the site and even lit the construction materials on fire. Tennessee's lieutenant governor actually endorsed the opposition and went so far as to state, "You could even argue whether being a Muslim is actually a religion, or is it a nationality, way of life, a cult, whatever you want to call it." When the county granted the necessary permit, some citizens sued, saying they hadn't been properly informed of the Planning Commission's meeting. Another argument was that Islam is political, not religious in nature, and thus undeserving of First Amendment protection. The arguments were so outlandish and offensive that the US Department of Justice had to get involved. It filed a brief explaining that the US does recognize Islam as a religion. The court agreed with the DOJ, and despite continued opposition, the mosque broke ground in late September 2011. The Islamic Center was represented by the Becket Fund. Now, in the semi-controversial category, you have cases like those defending the words "under God" in the Pledge of Allegiance, or cases defending religious displays, for example, Christmas and Hanukkah displays, or a statue of Jesus in the public square. This is where the average Muslim citizen may begin to lose interest. After all, how does a Christmas tree in the town hall or a statue of Jesus affect us? Some Muslims might even prefer to not have to encounter these symbols in public. But as I briefly discuss each case, consider the principles at stake, and consider why it's in our interest to protect those principles. One recent case brought by the Freedom from Religion Foundation, which I'm going to refer to as FFRF, involved a statue of Jesus on the slopes of a ski resort near Whitefish, Montana. The statue, which I will refer to as Big Mountain Jesus, was first set up as a monument to soldiers who died defending our freedom in World War II. After World War II, soldiers from the Army's 10th Mountain Division returning to Western Montana sought to commemorate their fallen comrades with a monument that evoked memories of the religious shrines and statues they had seen in their battles through the mountains of Europe. To honor these soldiers who had sacrificed so much for their country, the Catholic group, the Knights of Columbus, commissioned the statue of Jesus and applied to the US Forest Service for a permit to place it on Big Mountain. The Knights permit had been renewed every 10 years without incident until 2010, when FFRF sued to have Big Mountain Jesus permanently removed. FFRF argued that because Big Mountain Jesus stands on federal property, it is in violation of the constitutional principles separating church and state. The Becket Fund defended the statue. It argued that Big Mountain Jesus should be viewed as a military memorial, not as a religious shrine. After all, its permit had been renewed for years by the Forest Service without any issue, and for a long time, the statue was a site of all kinds of secular activity. The district court agreed, noting that Big Mountain Jesus has been the subject of much frivolity over the years, serving as a meeting place for skiers, a wedding location, and being festooned with ski hats, goggles, Mardi Gras beads, and other secular decorations. The Ninth Circuit Court of Appeals also agreed, ruling in favor of keeping Big Mountain Jesus around and explaining that the statue's secular and irreverent uses outweighed its religious uses. So the key principles here are, when the government allows its property to be used for various purposes, like a ski resort, then it opens it up to public expression. And it can't then exclude a memorial based on religious grounds. Government can't treat religious displays any better or any worse than other kinds of displays. Religious symbols should not be treated as inferior. We live in a pluralistic and diverse society. We celebrate diversity by encouraging the religious expression of private citizens, not by tearing it down. And our history, traditions, and jurisprudence do not require us to scrub all religious symbolism from the public space. Would we take the crosses, Stars of David, and crescents out of Arlington Cemetery? And I was going to discuss the Pledge of Allegiance, but I've just been given notice that I'm running out of time. So I'm going to move on to what you guys have been waiting for, which is the very controversial case category. And in this category, you typically have cases that involve sex, like Hobby Lobby, which involved the morning and week after pills, or the emerging issue of religious objectors to same-sex marriage. With these cases, the politics have gotten really nasty, with liberal media and activists claiming that the religious liberty claims are mere pretexts for outright bigotry. Most every American knows of, or at least has heard of, the Hobby Lobby case, and many Americans think the case is about religion waging a war on women. But that's not what the case is about. It's about the ability to live out one's faith free from government control. Hobby Lobby Stores Incorporated began out of founder David and Barbara Green's garage and has grown from one 300 square foot store to more than 550 stores across the country. Devout Christians, the Green family believes that it is by God's grace and provision that Hobby Lobby has endured. And they sought to honor God by operating their company in a manner consistent with biblical principles. And there's a number of benefits I was going to outline, but I will skip over, that really kind of show how much they're dedicated to these principles in terms of the pay, the work hours, and other benefits they provide their employees. And so when it came to this mandate, this healthcare mandate that required them to provide Plan B and Ella, which are the morning after and week after pills, which are widely considered to be abortifacients, they couldn't comply because it went against their very fundamental belief that abortion is a killing of a human being and that is against their faith. And it might make the Becket Fund quite unpopular in this group, but the Becket Fund represented Hobby Lobby, and as you know, in June 2014, the court ruled 5-4 in favor of the Greens and Hobby Lobby. No matter how freakish the media made the Hobby Lobby decision out to be, the case in fact reflects a fundamental component of the American dream, that every American, including business owners like the Greens, should be free to live and do business according to their beliefs. So having worked on this case and experienced at least some of the public storm around it, including the Muslim fury on Facebook over the court's holding, I was upset but not surprised that so many young Muslims accepted the left's twisted version of the case without inquiring more. Almost all of my Muslim Facebook friends took it as a given that the conservative Christians in this case were waging a war on women, and that the religious claim at issue should be overridden. There's also a general tendency to oppose conservative Christians because some among their ranks are vocally anti-Muslim. But at the end of the day, the legal issue and legal ramifications are what we need to focus on when deciding our position. And honestly, what better way to build bridges? Frustrated by the Facebook echo chamber, I convened a small group of DC-based Muslim activists, and we talked about the issues in Hobby Lobby and the implications of the holding for Muslims, including Muslim business owners like halal slaughterhouse owners, which are for-profit, and want to run their business in accordance with their religious principles. This simple 1-hour conversation completely changed my friends' perspectives on the case. More of that sort of engagement is needed. We need to look past the media headlines and figure out what is actually going on in the religious liberty arena and make informed decisions about the long-term impact on the Muslim community's interest. Among the many things that the Center for Islam and Religious Freedom seeks to accomplish is engaging the Muslim community through its leaders in a deeper, more substantive engagement on the value of religious liberty. We need to understand how even other faith communities' issues and struggles affect our position in this country. And beyond the question of the community's specific interest, how do these cases uphold a fundamental human right? Nowhere defended as vigilantly and consistently as it is in the US. Don't we want to be part of that fight to protect key rights? And don't we want to show up for others the way we hope they'll show up for us? We may not, in each and every case, agree on what the right answer or outcome should be, but at least there will be careful and considered engagement with the issues. The importance of religious liberty demands that of us. Thank you.